I'd like to welcome everybody and thank you for attending this webinar today about life changes and how to make sure your plan stays on track and tracks with those life changes. My name is Mark Kraus, and I'm an attorney with the estate planning department here at Copenbarger Copenbarger. I do want to let everybody know that you might have been expecting Charles Sosa, but instead we have Zachary Raymond, who's a partner with Lifestyle Financial. He'll be speaking on behalf of Lifestyle Financial after I do my portion. Just to let everybody know, this is like kind of the market investment guys. So if you have any questions about the market or anything like that, you can definitely take advantage of having Zachary here. He is a wealth of knowledge and has lots of thoughts. So if you have any of those sorts of questions, please go ahead and ask him. I would say that with regards to questions in general, we're going to be happy, both Zachary and I, to field your questions at the end. But we're not going to address them as we go. We'll save them for the end. So if you just put them in the Q&A, we will try to address everybody's questions at the end. I should say that this, a little legal coverage for myself, this is for informational purposes only, or educational purposes only. This should not be considered legal advice. So please don't sue me after this. This is just for educational purposes. Thank you for reviewing that disclaimer. If you look up here, this is, unlike some firms that do estate planning, which may just be one-man operations, we obviously have multiple attorneys across multiple different departments. In addition to estate planning, we have a business and tax department, we have an estate administration department, and a litigation department that can serve your needs. And we have offices. Here's a snapshot of our wonderful staff that help make us attorneys look good every day. And we have offices basically all over the state of California, from Northern California all the way down to San Diego for your convenience. Today's agenda, I'm going to be addressing major life events and how to align your plan to make sure it's consistent with those life events and updated in accordance with those life events. And then, as I mentioned, Zachary is going to talk to you about Lifestyle Financial and what they can do for you. So major life events. It's a very benign way to put it. Things happen. I might put it another way, something else happens, but this is a family webinar, so we're not gonna, we'll keep it G-rated there, but life does move at you quickly. And it's a very interesting thing to see from my perspective, because I get to see people at different stages of their life. They might have come in and had one kind of trust when they just got married and bought their first house, married couple. Then they might come in later after they have kids. And then they might come see me again after they have grandkids. And that same couple, throughout those different milestones, they're not going to have the same planning needs. Those milestones that you go through in life, they do affect your estate plan. They affect your priorities, your needs. And it's important to make sure that as you're moving through life, that your estate plan is growing and developing with you and with those life events. So I should say, neglecting updates can lead to confusion, disputes, unintended outcomes for your loved ones. And what that all means for me, the worst thing that it can lead to is litigation. The whole goal of doing your estate plan and doing a trust is trying to make sure that we're able to administer your estate outside of court. That's, one of the first goals we have. So neglecting to update it could mean that everything winds up in litigation. And most importantly, that your goals actually aren't seen through, that your actual wishes are not met. So two very dirty words in my line of business. The first one is conservatorships. You may have heard me talk about this before. I do not want anybody to end up in a conservatorship. Usually people's familiarity with conservatorships is basically limited to Britney Spears. If any of you remember the pop star Britney Spears, a little bit kooky, very, very rich. And so her dad filed with the court to get a conservatorship over to help manage her money and make decisions for her, because it was thought that she was not responsible enough or sane enough, frankly, to make her own decisions. The reason why we don't want you to have to deal with this is because A, it's something that you have to spend a lot of money filing with the court for. B, it's something that the court is going to engage in ongoing supervision of. You're going to have duties, if you are a conservator, to maintain accountings and report back to the court. So it's something that we want to help you avoid. Obviously, anything that deals with the court is something that we want to help you avoid. But luckily, we can avoid conservatorships through tools like an advanced healthcare directive and durable powers of attorney. Healthcare directive, in case you're not familiar, a healthcare directive essentially does three things. The first thing is it gives somebody, I don't know how many of you are familiar with HIPAA, but HIPAA is essentially like attorney-client privilege, but for doctors and hospital staff. So Advanced Healthcare Directive is going to give somebody an exemption from HIPAA so that they can find out what's going on with you. Then it's going to give that same person the ability to make healthcare decisions for you when you can't make them for yourself. And there's certain other wishes, especially surrounding end-of-life decisions, that your person that you empower under your healthcare directive is going to be responsible for seeing are carried out. The durable power of attorney, not to be confused with the durable power of attorney for healthcare, which is sometimes what we call an advanced healthcare directive. This kind of durable power of attorney is for financial things. So it essentially empowers somebody to help manage your finances and step into your shoes in a legal capacity to do certain things if you ever become incapacitated. These documents are designed primarily to help avoid the need for a conservatorship. These documents can be used outside of any court supervision so that you don't have to go through the time, expense, and hassle of going to a court in order to manage somebody's affairs if they become incapacitated. The other really, really dirty word, of course, is probate. We want to help you avoid probate. For many of you that have trust with us, or if you don't have a trust, please consider getting one. One of the primary purposes of having one is avoiding having your estate go through probate. Probate, if you're unfamiliar, very expensive, very stressful, a whole lot of rules to observe, which is why you typically need an attorney to help you navigate it. And best case scenario, at least where I'm at in Southern California, you're going to be looking at probably best case scenario, maybe a year and a half to get through probate, and possibly longer, especially if anything goes wrong. So obviously a living trust is a primary tool that we have to help you avoid probate. What it's able to do is you're able to put your assets in trust and set the rules for who's managing those assets, who manages those assets if you become incapacitated, and what happens to those assets after your death, and who's responsible for making sure that your end-of-life wishes are carried out with regards to those assets. And that enables you to have your estate administered entirely outside of any court supervision. Pour-over will is another tool that works with a trust. So for some people, a simple will may be enough. If you're, for instance, if you don't own any real property and your entire estate is worth less than $208,850, you might be able to just do a standalone will rather than a trust. But if you have a trust, a pour-over will works with your trust, essentially as a contingency plan in case anything is accidentally left out of the trust when you pass. A pour-over will is going to collect those assets and essentially direct them back into the trust. So these are tools that will help you avoid probate. So major life events that would cause a change in plan. Marriage and divorce are two of the biggest ones. When you're married, a lot of times what people need to do is combine finances, or at least if it's a mixed marriage, perhaps if you have your own kids and your new spouse has their own kids, then you have to do an even more often tricky dance of trying to combine households and navigate how that's going to work. That's definitely a time to revisit your estate planning. In addition to the financial aspect, you now may have stepkids that you didn't have before, and your spouse may have stepkids, and you may want to put some thought into how and to the extent you want to provide maybe for those stepkids, or to the extent if you enter into a joint trust with that new spouse of how you want to make sure your half of the things are protected. There's something you may be aware of called AB trust provisions, which we're able to do. One of the primary reasons for that is often in a mixed marriage or even in a non-mixed marriage. There can be some worries that if you pass first, that the surviving spouse might make changes that you wouldn't agree with. And while you can't 100% prevent them from making any changes, an AB trust will allow you to make sure that any changes they make are restricted to their half of the community property and any separate property assets. It'll make sure that those changes don't affect your community property and your half, any separate property assets for you. Divorce obviously is a huge reason to have a new conversation about estate planning, because you're essentially unwinding any joint assets, any community property that you had with your previous spouse. For sure, if you are divorcing a spouse and you had an estate plan that was a joint estate plan with them, we're going to need to essentially unwind all that and create a new trust and a whole new estate plan for you, because obviously your life is no longer wrapped up in that person's life. So if you're either going through a marriage or divorce, or if anybody in your sphere, like your children, are going through those issues, those are times definitely to come and have a conversation with us. New children or grandchildren. Obviously, the biggest transition is the transition from not having any kids to having kids. That is a huge milestone that requires estate planning. One thing people often miss is that unless you specifically provide for it in an estate plan, specifically in this case in a will, you don't get to have any say in who raises your kids if both you and the other parent pass away. If both you and the other parent pass away at the same time, say in a car accident, what you need to have in place is a nomination of guardian in order to have any say in who raises those kids if you both pass away. And that's something that's done through a will, whether it's a standalone will or a pour over will. That's something that we can help you plan for. In addition to that nomination of guardian, there's a whole lot of rules you can set up for what happens to your assets in terms of how those assets would be used to take care of your kids if you pass away. And sometimes it's a good idea to even, if you have both a trust and a will, to nominate one set of guardians and have somebody else be the trustee to actually be in charge of your finances. You may trust somebody to have both those roles, but sometimes it can be a good idea to protect your kids to have one person in charge of the financial aspect and the other person in charge of raising them. So that's definitely something that's different for everybody. People have different relationships with family and friends, different needs. So that's something that you're going to want to talk to us about, and we'll do some, very specific planning for you. Grandchildren's another thing. All your estate might have been provided for, a lot of cases, equal shares amongst all your kids, but having grandchildren might change things. You might want to put in a provision that provides for grandchildren to have some money for college or have a little bit of money to start out in life. You might want to add specific gifts for those grandkids. So that's another time where, when you start having grandchildren, to rethink things and come have a conversation with us. Career business changes. So if you do own your own business, this is especially something as you're transitioning, as your business develops, you are going to want to make sure that it's consistent with your estate plan. If you own a business, especially if it's an actual, corporate entity like, an LLC or a corporation or something, limited liability partnership, any of those sorts of things, you're going to want to make sure if you have an estate plan that business has some sort of relationship with that estate plan. They're not necessarily going to be things you want to keep separate. So if you have, say, an LLC, you're probably going to want to make sure one way or another that it's in the trust, or that the trust is, one of the owners of the LLC. So there's different ways to do that depending on your needs. So again, that's something we're going to want to have a conversation about. And in addition to the estate planning department, we do have a very good business tax department that can help you out with all sorts of things if you own your own business. And you also definitely want to think about what's going to happen to that business after you die. You want a succession plan in place. And there's also different kinds of estate planning things that we're going to want to think about if you're going to sell your business, if you're going to retire and sell it. So those are all reasons as you're going through these transitions to come have a conversation with us. Relocation. So if you move, obviously you're going to want to make sure everything's in place before you move. Make sure that if you buy any new properties, that you're rethinking your estate plan. That can sometimes circle us back towards the LLC conversation. Let's say if you've bought investment properties, whether in California or another state, it's a good idea usually if you're going to own some investment properties that are not your primary residence, to probably have some sort of protection in place, like an LLC, a structure to limit the liability, so that if one of those tenants decides to sue you, that they can't come after your house as well. So that's something as you go, you're going to want to have further conversations with us about. Regular things to kind of do to ensure regularly on a regular basis. Make sure that your estate plan is updated in terms of legal compliance. New laws do come out from time to time. Things like you may have heard about Prop 19 a couple years ago. You might have heard about the Secure Act recently. These are things that you're going to want to be aware of. We usually, if you're a current client, we're going to send email blasts and things like that out. But this is a reason to do webinars, to come to client seminars that we put on. And we just recommend in general every 3 to 5 years at least that you come see us, so that we can have a conversation and make sure that your estate plan, in addition with all your life changes, is tracking with changes and updates in law. You're going to want to make sure you look over periodically your trustees and all the other decision makers in your estate plan to make sure that these people are still the people you want in charge. For instance, you might have, when you first did your trust, if you were a young couple, you might have your parents as your successor trustees. Well, 20 years later, your parents might not be the best people to be those successor trustees anymore. Maybe now you want a sibling to do it. Maybe your kids at some point might be old enough and mature enough. You know, granted, the bar for when kids are mature enough to be your successor trustees maybe has moved in the last few years. I sometimes say that 30 now isn't what 30 was back then in a lot of cases. But it might be at the point where your kids are old enough to take on that responsibility. So you're going to want to make sure. You could have even had a falling out with one of your decision makers, or they could have died. So it's something that you're going to want to make sure that you regularly look at those decision makers, successor trustees, attorneys, in fact, for healthcare directives, durable powers of attorney, and make sure they're the people that you want in charge still. Same thing for beneficiaries. Maybe you had a really good relationship with someone in the past that was going to get a portion of your estate. Maybe you don't want to give that to them anymore. Maybe you had a falling out, or maybe they just died. So you're going to want to make sure you're also updating your beneficiaries and making sure your distribution portion of your trust is in line with your current relationships and your current set of values. You're going to want to, I would also advise you in general. So when we say providing clear and current instructions to family members, there's something that you can include with your estate plan called a letter of instructions. And this is a pretty versatile document that can cover a lot of different grounds. It's something that you really make your own. You might want to tell, leave instructions regarding where certain assets are, like you have something in a safe deposit box. If you have any crypto, that's something that there's, say, just like one flash drive or one, key to access that crypto, you're going to want to make sure that that's something you leave instructions about how to access and where to find things. You might also want to leave instructions about how to contact certain important people. Maybe your kids don't automatically have all your beneficiaries, in their saved in their phones. So these are all things that you're going to want to make sure, if you have letters of instruction, that you keep those clear and current. Make sure you update them as needed. And in general, in terms of family disputes, I typically advise people from the perspective of someone that's done a lot of litigation in this space, which I have. One of the best ways to avoid litigation is to make sure that nobody is surprised when you pass away. Make sure that in general, that, if we're talking about your kids, that they know what's in your estate plan, whether they like it or not, ahead of time. Make sure that they're able to make their peace with that and get acquainted with it well before you die. I think that can go a long way to helping avoid having legal disputes after you die, if everybody's just aware of it well ahead of time. Oftentimes what I see leading to litigation is something that a kid thought what they were going to get that they're not going to get, and they're surprised about it, and they find out when they're in the midst of grief. It's a good recipe for litigation. Look out for evolving probate and trust administration rules. Obviously, we're going to keep a close watch on these things. We'll try to let you know any way you can, but if you miss, the email blasts and other sorts of things, again, check in with us every couple of years to make sure there aren't important changes in law, such as the threshold to do a probate previously, the threshold for which it would require your assets to go through a probate used to be $184,500 for the total value of your estate. As of April of this year, it is now $208,850. So rules are changing all the time. Enhanced digital asset and legacy planning. I did a webinar recently about digital assets. This is an emerging field, and it's going to require, as the type and complexity of your digital assets increases, is going to require increased sophistication in your planning. So that's something to definitely try to maintain a regular dialogue with us about. Tax planning and gift exemption updates. You may or may not be aware that the current gift tax threshold is $19,000, so that you can give pretty much anybody $19,000 without anybody telling the IRS about it. That's something to be aware of, and that it does change periodically. So for those kind of purposes, you're going to want to make sure that you're aware of any of those updates. Expanded protections for vulnerable adults and elders, especially as the population is currently aging and aging drastically. This is an emerging area of law that lots of political advocacy groups like the AARP are constantly trying to push for different kinds of legislation to protect our seniors. So this is something you want to be aware of and have a regular conversation with us. Revisions to property transfer and real estate inheritance rules. One of the big things here would be Prop 19, which drastically changed and restricted the parent-to-child exclusions that you can potentially get for having your property taxes reassessed when you transfer real property to a child. So you're definitely going to want to be aware of that in your planning. If your planning involved you leaving real property to your kids and you made the plan prior to Prop 19 going into effect in 2021, that's something that you're going to want to be aware of and perhaps rethink. Adjustments to retirement account and beneficiary planning rules. There's something you may or may not know about called the Secure Act, the second part of which went into effect in 2022. That may affect how you should be dealing or how your trust should be dealing with deferred compensation accounts that are going to be inherited, like IRAs and 401ks and those sorts of things. So you're just definitely going to want to be aware of that and make sure that your plan is updated in accordance with those changes of law. So aligning your plan, how to make sure that your plan is actually aligned and tracks with changes in law and the changes in your life. You want to make sure that your plan, when it's done correctly, it can shield your assets from unnecessary taxes and probate costs. It can provide guidance through medical and financial decisions through those powers of attorney and make sure that the right people are in place to be responsible for those things if you become incapacitated. You can offer long-term care protections and designate who manages your affairs if you can't. It's a very important thing to be able to fully avoid those nasty conservatorships and any issues like that. You're going to want to ask, as these financial goals and your family priorities evolve, you're going to want to ask yourself, does my current plan reflect my personal and financial goals? Your finances are something that are going to probably wildly change. If you first, if you did your first estate planning when you're a young married couple, by the time you're ready to retire, and certainly, a decade or two after retirement, maybe even, your financial status is not going to be the same. This country is incredibly financially dynamic in the sense of, we talk about the 1%. Who's in and out of the 1% is something that shifts drastically as people age. So as your finances and your financial state develops, you're going to want to make sure your plan tracks with that. And you're going to want to make sure that, like I said earlier, trustees, executors, and agents, make sure as those relationships develop and the people in them live their own lives, that they're still the people that you want, that they're still the people best positioned to be in those sort of fiduciary roles. Especially, you might have a situation, I've had plenty of situations where, they have some people on their healthcare directive, and then it turns out that one of their kids or even one of their grandkids becomes a registered nurse or even a doctor. Might be a good time to move that person into the first position on your healthcare directive. If one of your kids, say like me, my parents, I became a lawyer, suddenly that became a good idea to have me as a trustee listed in their trust because I'm an attorney that practices in this space. So in addition to all the deaths and other things I mentioned, these are things you're going to want to watch out for to make sure that your decision makers are who you want them to be. And your values and legacy wishes might change over time, or some of the beneficiaries that you have set up that are theoretically aligned with your values and legacy wishes might have changed themselves. One thing that our clients run into pretty routinely is if they're going to leave a sizable donation to a charity, that charity might have aligned with their values at one point, but after a couple decades, the leadership might have changed in that charitable organization, or your values might have changed, and you might realize that's no longer a good fit. So if you have one set of, distribution provisions, especially charitable giving, at one point in your life, you're going to want to make sure that that's still a good fit for you as your life develops and as the organization develops. And that's something that we can definitely help you with. Making changes, please, please, please. This is not a DIY. Some things are great. You can go to Home Depot. You can maybe replace your faucet fixtures. There are things that you can legitimately do by yourself. This is something, if you're going to change your estate planning documents, please have a professional do it. I can't tell you how many times I have wound up in court with confusing jots and tittles written into the margins of a trust, or other amateurish, amendments typed up on a laptop, or even, at one point in time, a typewriter. They can wreak havoc on your estate. Like I said, oftentimes the first goal of doing your estate plan is to keep everything out of probate court and to make sure the court's not involved in the administration of your estate. If you want to make sure that your estate keeps out of court, please do not do all these changes on your own. Come talk to us about them. whether it's updating your trustees, changing your distribution provision, updating the powers of attorney. There's all sorts of problems that can be done if you try to do them on your own. And as we always say, an email is not enough. You sending me an email saying, hey, I want to change my trustees, that email is not part of your estate plan. That does not change your trustees. These documents have a certain degree of formality and different kinds of formalities that need to be observed to make sure they're valid. So again, I've seen many, many problems, not only with do it yourself, but going to non-attorneys, sort of paralegals and even financial planners to do your estate planning and to make these changes. And I've seen a lot of horror stories. So please, I would advise you to come see us if you're going to be making those changes. Updating beneficiaries. Want to be clear right here where it says can be done yourself. I am not talking about updating the beneficiaries in your trust. I'm not talking about updating the beneficiary trust. We're talking about updating beneficiary designations on beneficiary designated accounts like IRAs, 401ks, even life insurance policies. So you're going to want to make sure with those as well, because that's another layer of planning. Sometimes you might have the trust listed as a beneficiary on some of those accounts, but sometimes you might have your kids or somebody else individually listed. And whether or not that's a good idea is going to depend on the individual and your goals. But you're going to want to make sure that as you're updating your trust and your other estate planning documents, that you make sure that the beneficiary designations on your IRA, your 401k, your life insurance policies, any of these kinds of accounts are also updated as well. If you change, for instance, let's say you have a complete falling out with everybody that was previously the beneficiaries in your trust, and you make sure to amend your trust, but you fail to update all the beneficiary designations on those other accounts, you might have a substantial amount of your wealth going somewhere you don't want it to go. So make sure that those are updated. Changing executors or trustees, again, please do this with an attorney. Do not do this yourself. Even if you think it's really simple to just cross out a guy and write in another guy, that can create a lot of ambiguity and problems. It's not the right way to go about doing it. Adding and removing assets. You might have purchased new real estate. Oftentimes your financial accounts are going to change. Maybe you closed account at one bank, opened a new one. Maybe you had an investment account that got bought out by a different company. That happens all the time. Charles Schwab may have gobbled up whatever your investment account was before. It's important to make sure, especially that your schedules of assets in your trust are updated. So that's something we can help empower you in some cases to do that yourself. We try to give our clients the ability, when we give them flash drives now, to give them templates to enable them to properly update those schedules of assets themselves. But if we haven't done that for you yet, or if you just have any questions, definitely use us as a resource to make sure that those schedules of assets are updated properly, and to make sure that everything is in the trust that's supposed to be in the trust. Everything that's not in the trust has proper beneficiary designation so that you have a cohesive, coherent plan. Amending distribution terms. Please, again, don't do this yourself. It's really important. You don't want to, your distribution plan terms of your trust or your will decide where all your stuff goes. Obviously, that's the two biggest things are who's going to be in charge of your stuff and what are they going to do with it after you die. Don't take a chance on it. Just, have a professional advise you so that you do it properly. Updating guardianship provisions. You're going to want to make sure, again, as you're updating these other fiduciary provisions, if you've nominated guardians to take care of your kids, obviously that's something you're going to want to make sure that your wishes are still in line with those documents. You do not want the wrong people in charge of raising your kids. And you're also going to want to make sure that your trust, the plan, the overall, there's a cohesive plan between your trust and your will, if you have a trust and a will, to make sure that the responsibility, the guardianship is provided, and that you have who you want to be in charge of the money, and that the money is going to go where you want it to go in terms of the raising of your kids if you're gone as well. With that, there may or may not be some questions, but like I said, we're going to definitely hold off into the end to answer those questions. And I want to turn things over to Zachary from Lifestyle. And I thank you for your time and your attention.
Yeah. Thank you, Mark. Good afternoon, everybody. Thank you so much for joining this wonderful presentation. Just want to say how appreciative we are at Lifestyle Financial for a very long time with a relationship with Copenbarger and Copenbarger. We always learn a lot because, as Mark had mentioned, when you're dealing with any professional capacity, you want to understand the realms in which you specialize in. So as Mark had mentioned, and I want to start here with you don't want a legal decision done by a financial planner or the advice outside of a legal professional. You should go to a lawyer, go to Copenbarger. They will give you the right advice and guidance. You also would want a financial planner able to comprehensively talk about all these investments that will be in your estate plan. You've gone through all this work to set up four walls of a document to govern the finances or the legal characteristics of your estate plan. Then you want to enforce it with that sturdy and steady conscience and hand from a financial planner that understands your specific situation. So a few topics that we're going to cover today about the history of Lifestyle Financial, the importance of investments in your estate plan, and a little recap followed at the end by a question and answer session with Mark. So Lifestyle Financial has been around for the better part of 30 years. Essentially, what I like to tell people is we cover everything that if it involves buying or selling, investing, anything more than a dollar, we generally speaking can talk and advise on it. Our role is to understand your specific situation and then apply it to the universe of investment planning. Because really, as we spent the better part of this webinar talking about all of the complexities in estate planning, there are unique characteristics in the financial component that goes into your estate planning. And you have to customize that, and you have to take that whole process and then be able to build on it for the entire lifetime of your estate plan. Not just until you retire, but until your time is done, and then your trust gets administered, and even your wishes, such as charitable strategies or to your heirs and beneficiaries, get properly implemented. Having the right sort of financial professionals being your trusted counsel when it comes to all these financial dealings is very important. And we take a methodical process to best understand where you are, where you're trying to go, and help you on the financial side of your estate plan accomplish all of these goals. So a few topics of conversation that we'll address today include diversification and its importance, the value of our firm. We do try to be an education-first financial planning institution and cover a great deal of the investments that go into an estate plan. As I mentioned, there is a lot in the investment universe, not just stocks and bonds, not just buying and selling. There's many different vocabulary words. I always tell people we're not here to tongue twist anyone or confuse anyone. Finances are supposed to be very straightforward so that you, the CEO of your estate plan and the financial components within it, can help us best administer your plan or be a sounding board. Very importantly, you want someone who will be with you hand in hand in investment decisions. And even though not always the best conversations, arguably the most important conversations, give you sound feedback. Maybe it's a different perspective, something you're looking towards. One of those happens to be diversification. There are many very profitable, big, historically sound investments in the markets, in investing in general, whether it be real estate or intangible assets or liquid or illiquid assets, which is a fancy way that I would say stocks or real estate or alternatives. You never want to be overly positioned in any one place, not necessarily because at any one day or time that position can go bankrupt or disappear, but because maybe there is a day that you need access to some value, you need access to funds, and everything is tied up to a company stock. If you are up in Northern California, where I live in Silicon Valley, there are a lot of very profitable companies here that, for example, give stock as part of your compensation. So I always tell people, you should be married to your partner, not married to your company. So yes, you are getting paid in this stock. It may even offer you a dividend or a chance to grow as the company grows, but you are also getting an income, in many cases a W-2 income, a 401k and a match from the employer, and certain benefits. You do not also solely need that company stock, because it's overly concentrating you. And every single stock in history, and we can go in our conversations with clients and people who want to consult with us, we always give examples of specific companies. And in the history of companies, there's always been changes. All things are certain until they are uncertain, I like to say, when we have these conversations. So we want to take some of this concentration risk away because diversification is a healthy part of building an estate plan and reinforcing with many different layers and sectors or particular strengths that can be pulled as levers when they're needed, when there are life events. If you want to help pay for a wedding for your children, if you are taking a college fund and you want to know the right structure to fund for college, within your 401k, if you want to review your options versus just an employer stock plan. If you are a teacher or you're in what's called a 403b and there's a pension component, you want to know the inner workings of these pensions. All of those financial dealings will then multiply over the decades until you retire. Your estate will go through a change. And then you're going to want to know that you had this diversification process built out and a team working with you to help maximize the decades of work and contribution you gave to these investments without risking any one point in time seismically changing your investment plan. In diversification, what is really important is understanding your risk profile, understanding what it means to be diversified. I always tell people not all stocks are created equal. Some stocks are much more reliable, say for income or dividends, we call it, or some stocks are relied on for growth and not even producing income or dividends. You can have bonds or certificates of deposits, which are CDs, which is a type of bond, or you can have alternative assets. There are many different ways to look at diversification, but an important component of that is your risk profile. Is if your entire estate were to go down 1%, how comfortable are you with that? If your entire estate were to go down 1% over a day versus maybe over a month because there's a volatility in what you are invested in, is that okay? Can you weather that storm or have a financial team behind you to be your sounding board, to tell you what is going on and do the best that they can to give you the full picture, never just a partial picture, but a full landscape of what is going on so that for the long term, you know your plan is in good place to accomplish the financial goals that are in your estate plan. This is where the education comes in handy. I routinely like to give personal examples. There's a very deep-rooted financial thought that the best way to understand a concept is to give a relatable situation. So people going through buying a house, people going through investing in real estate through an LLC, or building up the investment accounts in their trust plan, in your Schedule A, tracking all of these investments. We try to sometimes give personal examples because it familiarizes you with these situations. And there's many layers of complexities. For certain young couples just starting to get married, building for enough to buy a house in the state of California, that might take longer than in other states. We are licensed all across the union. So if you go to another state, we are able to give you investment advice wherever you may go. The complexities of having children, planning for college, the questions about if you go from one employer to another, what is the best thing to do with that retirement plan? Also, within that plan component, making sure all the beneficiaries are up to date. That is an overlap in your estate plan that you want your financial planning team to be aware of. You want the right beneficiaries on retirement accounts. Say 30 years go by and you've gone through a divorce. Well, you might have the divorce. It might be updated in your estate plan, but your 401k still lists your former spouse as the beneficiary on your 401k. You have to go in there and change it. Same with bank accounts. You've gone through all this work to build an estate plan. I can tell people routinely on a statement whether or not that bank account is in your trust. Also, who has access to that bank account. The changes in the investment landscape has gone through one undeniable change, that information comes quicker. Personally, I think that the rate of innovation is a wonderful concept. It allows people to become more aware of what's happening in the investment landscape. It also demonstrates the value of your financial advisors to not only stay up to date on all the relevant parts as it relates to your particular financial plan, but it allows us to continue to monitor and guide and help to advise on all of these moving parts at once. Any given day, there's a multitude of things happening in the market, even over the weekend, that could determine real estate values, cybersecurity strengths and threats that will directly correlate to how a stock might perform when the stock market opens the following week. These are all things that we take into account when building out your plan. There is even strategic opportunities to reinvest, or as I tell people, maybe you have a Schwab account. That's fine. Maybe you have a TD Ameritrade account that Schwab acquired. As Mark had said, there's been this great consolidation in investment firms. They routinely change names. At the same time, there is also all these stocks that get bought and acquired by other companies. So the question then becomes, a company that you thought you were invested in that now is a different company, you bought at a certain time and price. What is your sell strategy? I routinely ask people this because I have a buy and sell strategy for every single investment that we talk about in your specific plan. And you need to update that, especially as then you go back through the years and decades into your estate plan. We briefly talked about this, the different types of investments. There are many more than what you see on the screen, but very broadly, we have retirement accounts, which generally you would think of as an IRA, an individual retirement account, or a qualified or planned retirement account, most commonly called a 401k or a 403b. These are simply areas of the Internal Revenue Code or the tax system in the United States where they are classified in. Many of them have similarities, the biggest one being they are tax shelters. That means that money that's in there and moves around, you don't have to worry about a tax consequence. No, financial planners are not tax advisors, but that's not an excuse for us to not be aware of the impacts and the taxable events. So routinely, when we talk about retirement assets, we are also talking about them on a tax-aware basis. That's vocabulary that you might hear from planners, tax-aware. That's what we're trying to get at. And you need to hear that disclosure that we're not giving you tax advice so that you know very much we're talking about the investment side of things, and we're also aware of the taxable side of things. As you go on in your career, as your finances change, generally speaking, the largest component outside of maybe your primary residence, your largest basket or nest egg, if you will, is going to be your employer retirement accounts. For some people, that might be 50 years working at the same company or 40 years, however long it may be, or you may have moved employers. You may have been self-employed. So you might have had what's called a SEP IRA, SEP IRA. We take all of that into account, analyze the best way of handling these investments, and then we can have a conversation about what to do, not only as you approach retirement, because you're actively planning for that point in time when you're no longer directly working for an employer, but also after retirement, which, as again, Mark had said, people are living longer. These are becoming, retirement accounts are becoming one of the largest portions of investments for many people in America. And so it's more and more in the thought of everybody's mind, how to best handle these funds. Should I do what is called a Roth conversion? That's a specific type of retirement process that we go through your plan. It is a taxable event. Do you want to change from a traditional contribution style to a partial traditional Roth contribution style? Does your employer allow these? Just because you can do these things and you've read about them, you have to make sure employer retirement accounts actually facilitate them. Or if it's an IRA, have you made too much where you can't directly make Roth contributions? We look at all of this and help you analyze the best decision in your current part of your financial plan. And it will change over time, which is why we routinely want to go back and make sure that we are updating your financial information along the side for your retirement asset growth and health. Non-retirement is every other type of retirement account, and there are a lot of them. As you grow and build your wealth portfolio, Your illiquid or liquid investments are all non-retirement assets. There are different ways to fund them. There's different versions of these accounts, and there's different titling of these accounts. We help identify what is most suitable for your current situation, walk you through the pros and cons, and then build out the strategy alongside you to come up with the best investment plan. All the while, this is maintained in the four walls of your estate plan documents. Sectors of investments, as I mentioned, there are many different ways to invest. Uh, by and large, you want to invest in areas that are not overly concentrated in any one position at any one time, but there may be some rotation of value of being in, say, a sector called healthcare versus a value in being a sector called technology or financials. Those are examples of certain sectors of investments. The other way of looking at them, though, is are you in more of a growth sector or an income sector, a defensive sector, a private sector, which would be something like an alternative investment? That is how we classify sectors of investments. They all have a place. You just have to figure out how much and is it appropriate for you at a given stage of your investment path, which is for your entire life, not just until retirement. Investing stays with you as long as you are here. Ideally, you do not outlive your assets. So a few things to take home, the value of diversification and why, planning and education, and the various types of investment assets that we cover. There is underneath all of this an expectation that you should work with a financial planning team whose mission is to guide you through all of this. There is no one size fits all in investing. There is no such thing as a bad question, but the questions that are not asked. So we encourage questions because that's the best way we can understand how to build your financial picture and then go about the long term of investing. We can't predict tomorrow, but what we have done a very methodical job for the 3 decades Lifestyle Financial has been around is we remove unknowns from the situation. We understand because we pay attention to the other trusted professionals you have and have gone to, your estate planning attorney, to build these four walls of a document. Well, then we take a look, go into the finances, and we are squarely focused on growing that financial portion in your estate plan to accomplish your wants and needs and down the road, such as charitable strategies. As you have gone through all of this work to make a charitable distribution part of your trust, maybe you want someone who monitors those investments so that the overall giving you can do can be maximized, not just during your lifetime, but in perpetuity or for the lifetime of the investment account itself. It can simply have instructions. You have to relate it to your estate plan. And then you trust the advisory team to keep on monitoring and managing those investments. That allows more to be done. With retirement accounts, as Mark had said, there's a lot of changes in the legal landscape. We understand what the Secure Act did, Secure 2.0. We understand stretch provisions. These are financial tools that we then leverage to figure out the best way to maximize the value of those tax shelters and the beneficiaries that you want those assets to go to. If there is a question of protecting assets, we also go through insurance and annuities. If there's a question of needing collateral, we run a simulation on how to borrow tax-free against yourself from an investment level. That's a very complex way of investing in your estate plan, but it's worth commenting on and discussing about if it's appropriate for you. So we understand that, and then when we have a conversation, we're best able to present this if it's appropriate. So moving forward, you may have questions. You might know someone who has questions. Maybe it's a conversation worth having. I always say if one person is having this conversation, you should talk to your spouse, be on the same page. I routinely will say, I've seen a lot of this. Money makes people do very weird things. I'm paraphrasing there. You can insert what weird is substituted for as a word. There is no harm in talking to us. Anything that you say to a financial professional, especially Lifestyle Financial, is confidential. It doesn't cost anything but your time, and it's worth it to us because if nothing else, we're able to help maybe point you in the right direction. Maybe there's something you need to go back to your estate planning attorneys, and the wonderful attorneys at Copenbarger are very good at this and following up with you. This is how we can best help the financial components within your estate plan. Mark, I think you're up.
So conclusion, how can we help? Well, um, we're obviously here to help you establish an estate plan if you haven't already established one. You know, we want to protect what matters most to you. We want to make sure that your family is protected. We want to make sure that you have the right people in place to make sure that all your wishes for your estate are carried out. If you already have a plan with us, but maybe you haven't looked at it for a while, please come in and by attending this webinar, you'll be able to have a free appointment, whether it's a review or if you're coming to us for the first time to consider your estate planning for the first time, your appointment will be free for attending this webinar. Why work with Copenbarger? Well, unlike, some firms, including some that I've worked with that are more one or two attorney outfits, we have, as you've seen, 10 full-time attorneys and one attorney of counsel. We've been open essentially since the 70s. We have over 350 years of combined experience. Some of our attorneys have advanced tax degrees and other certifications, including certified specializations in estate planning and probate. We have large, highly qualified staff that supports all the attorneys. And like I said, we have the ability to meet you where you are. We have 8 different office locations, and we can meet you pretty much anywhere on earth via Zoom or even other kind of telecommunications. So please utilize the opportunity for attending this webinar to come schedule an appointment to talk with us, and please use the opportunity to also talk to Lifestyle. If you see this slide up here, I want you to just pay special attention to the fact that if you look at the far right, the digital evaluation, we really want to know how you think we did. We really value our feedback, and we really do react to it and take it into account. So if you would please, before you sign off, make sure you fill out that digital evaluation. It's very helpful to us. And please, reach out to us at any time, and, Lifestyle's there for you to reach out to them as well at any time. I believe their contact information was put in the chat by David right at the beginning. Now, at this point, I believe there may be some questions, perhaps for myself, perhaps for Zach, perhaps for both of us. So I'm going to go ahead and take a look at the Q&A. The first question I see in the Q&A, how to minimize or eliminate capital gain tax selling house in California, moving to a different state. Do you want to tackle this, Zach? Do you have any thoughts about this, or?
Yeah, so it's a good question, and probably if you own a house in the state of California, your biggest pain is it's very expensive. There are exemptions. I would work with a Copenbarger attorney to know what the maximum exemption is that an individual has, or if you're married, the joint exemptions. There are exchanges in the tax code. But again, that was where we would have a conversation about your tax situation. You can do certain offsets of part of the gains from realizing losses elsewhere. You have to be very careful about this. Again, the tax side of things, we need to know a little bit more about your specific situation. If you have a very low cost basis in the state of California, you will be most likely paying some taxes if you move out of state to buy another house. That's what I'll chime in. Mark, if you want to.
Yeah, typically, I mean, usually from the estate planning perspective, we usually just try to encourage people to not sell their houses during their lifetime, especially if it's a house in California. I know if you're of a certain generation, you might have bought a house for $35,000 that's now worth, $1.2 million. That's not uncommon. And that can be a real problem. So usually, in order to avoid capital gains, the best tact is to have that house ultimately pass it through your trust after you die. Selling it, there's going to potentially be, maybe 250,000 that we can get an exemption from. We'd have to know your exact circumstance to really advise you. But there's not necessarily a silver bullet there if you're selling your house and moving to a different state that we're going to be able to do for you to avoid capital gains. But if you come talk to us, we'll at least be able to, give you an idea of what you might be looking at. But typically that's why we prefer, keeping the house and avoiding capital gains through, having it pass through your trust. Do we offer tax return services? I would have to. We do prepare tax returns from clients sometimes. I don't know if that's something that's just um, open to everybody. I think we do have our business and tax departments. If you have especially any specialized, I mean, we're not typically doing, just everybody's income tax like H&R Block, but we do have tax professionals. If you have any particularized tax issues or things you're concerned about, or especially if you have some issues to deal with the IRS about, that's something that the business and tax department can definitely schedule an appointment with you about, and we can talk about that further and see what we can do for you. What are the differences between owning home in the trust and the parent-to-child exclusion provision? So the differences, they're sort of, you can own a home in a trust, or own a home not in a trust, and it's not going to change the parent-to-child exclusion provision. So previously, before Prop 19, any transfer of real property from a parent to a child was going to qualify for the parent-to-child exclusion, which means that the house would not be reassessed in terms of property taxes. That's Prop 19, which went into effect in 2021, drastically restricted that down. So now the only parent-to-child sort of transfers of real property that qualify, or if the parent was living in the house for at least 2 years as their primary residence before the transfer, and the child is taking that house as their primary residence. So those are the only kind of parent-to-child transfers at this point that are going to qualify for that exemption from reassessment. That's something we can help you potentially plan for in your trust. Oftentimes it's a good idea, especially if you have multiple children, to maybe build in a right of first refusal to help preserve, the best possible scenario for maybe one child, or even a different child, to choose to take the house as part of their inheritance so they can take advantage of that exclusion. But they're essentially, they're related, but they don't have to be related. That's essentially the answer to the question. Is there a way to set up accounts for grandchildren without having their social security numbers? I'm going to probably defer this question to Zach.
Yeah, so it depends on the kind of account. And the question would be is eventually, do you want the children to be responsible for the taxable impacts of that account? Or is this something where you just want to set money aside for these grandchildren? Maybe they aren't aware of it, and then eventually, or if certain conditions are met, they then become aware of the funds. An example I could give is there are people commonly know of 529 accounts. Mark, I know you have some kids, you might know of 529 accounts. Well, you don't need a kid's social security number to actually set them up. You need a social security number, which can be your own. And then over time, you can eventually transfer that. That is actually part of the provision in Section 529 of the IRC that is still ongoing, because 529 accounts are relatively young in investment account world. That's a general example I can give. But if there's something more specific, depending on the grandchild or grandchildren or the relationship, there are some other ways of setting up an account for a grandchild or not the person funding the account, and you don't need their social. Eventually you will, but you don't need it right away. Hopefully that answers the question a little bit.
When giving to charity, I've been told to avoid percentage as recipient can then require an estate valuation. Do I agree? So insofar as I think I understand the question, yes, if you give a percentage gift, like you provide that a percentage of your estate is going to go to a particular charity, say in your trust, then they're going to be entitled. I mean, any beneficiary that you list in your trust is going to be entitled not only to notice of when you pass away and it's time to start administering your trust and who's going to be doing the administration. They're also entitled to receive a full copy of your trust, including any amendments. But if you do provide a percentage of your overall estate, I think what you're getting at is the trustee is going to have to give them an accounting at the end before making their distribution, which shows them how their share of the estate was calculated. And through that accounting, they will get to know, what the status of your assets were when you passed and what status they are now that the trustees prepared to make distributions to everybody. If you leave them a specific dollar amount, which isn't always the right, I mean, there's depending on your situation, there's good arguments to be made, maybe for a percentage versus a dollar amount. In fact, unless the dollar amount's a relatively insignificant amount of your estate, I usually recommend a percentage gift. But that said, if you leave them a dollar amount, specific dollar amount during the administration, the degree to which they're entitled to accounting is restricted to what's relevant to their share. So basically, you don't have to give them a full accounting if you leave them a specific dollar amount. As long as you can assure them that they're going to get that dollar amount that deals with their concerns. You don't necessarily have to give them a full accounting. Hopefully that, I think that answered what you were getting at there. I'm going to check the chat because I think we've got, I mean, you could still, it's still another maybe minute to ask another question, but I'm going to check the chat to see if there were any other questions that were in the chat and not in, let's see, looks like let me see. Can I change my living trust into a single instead of marriage? Changing it is maybe not possible. One thing we can do is, well, especially if you get divorced, what often happens is that we basically take all the assets out of that marital trust and essentially, make sure it doesn't apply to anything anymore. And then we create a new trust for the single person if that's our client. So what you can do is, you can take your assets out of that trust, any assets that you have the ability to take out of that marital trust, and you can create your own separate property trust. That's really going to depend what's going to be best for you in this kind of a situation really depends a lot on the specifics. I don't know if you are just want a separate property trust with certain separate property assets, or if you're getting a divorce. Those are really relevant questions. I will say it's also important to note that you can hold, even if you're married and you have a marital trust with, two people on it, each one of you can hold separate property in that trust that remains separate property. So there's a lot of moving parts there. I think we just would need to get a little clearer picture before we give you clear advice about what to do there. And I think that's going to do it for the questions. I think there's one other question just popped in. What is a family trust and is there advantage to this approach? Family trust isn't really a technical term. Trusts can be set up for families. Like usually it's just a way of naming the trust, like a really common way to name a revocable living trust when it's a married couple that has a family. They may call it my last name's Kraus, so we might call it the Kraus Family Living Trust or the Kraus Family Trust. Probably what that is just a normal revocable living trust. So the advantages to having and that's kind of your standard trust that people think about when they're doing, basic estate planning. There are irrevocable trusts, meaning it's either impossible or very difficult or restricted in a lot of ways to make any changes to those trusts. Those are usually used for more specialized kinds of planning. Like you can have a life insurance irrevocable trust, an ILIT. You can have irrevocable trust designed for Medi-Cal shielding purposes, other things as well. But most normal estate plans are, the backbone of them is going to be a normal revocable living trust, which is probably what you were thinking of when you're referring to a family trust. And the main advantage is just because it's revocable, that means you can change it during your lifetime. By creating an irrevocable trust, you're kind of handicapping yourself a little bit. You're making it so that it's either impossible or very difficult to make changes to it. So for most people, for their basic estate planning purposes, a revocable living trust is what you're going to want to prepare. So hopefully that answers that question. And I'll give it another second, but I think we're probably done with questions for the day. Okay, I'm gonna say that we've handled the questions. I really appreciate everybody's time once again. Thank you for joining us in Lifestyle today. I want to thank Zach for being here today. I found his presentation very informative. It was very, fun for me to watch too. And I just appreciate all you people for being with us today. Please take advantage, contact Lifestyle, set up an appointment with them. Please contact us, set up an appointment with us, a free appointment with us. And please, if you haven't done so already, please fill out that digital evaluation link. Thank you very much, everybody.